Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Alamin Adzlan. I and my friend which is Muhammad Hafiz bin Osman will be present about discharge of contract. Discharge of contract. When two or more parties enter the contract, each of them has a duties or obligation arising from the contract. Seller has the duties to deliver the goods sold and buyers under the duty to pay the price agreed. On fulfilling the contract will be discharged. When a contract is discharged, it is actually terminated. Once the contract is discharged, the contracting parties are released from further obligation under the contract. There are four modes of discharge of contract, which is one is by performance of the contract, second is by consent or agreement between the parties of the contract, third is by impossibility or frustration, and lastly is by breach of contract by any one of the parties. Discharge by performance. When the parties have performed their contract by carrying out promise under the contract, there is a complete discharge of the contract. If only one of the parties has performed his part under the contract, he alone will be discharged from the contract. The other part are still bound by the contract until he performs his promise under the contract. The performance here must be in strict accordance with the term of the contract unless otherwise agreed by the parties. Section 14 provides, unless he has signified his acquiescence in its continuance. Time of performance. If the time of the performance is important, any delay by one party, however slight, will entitle the other party to free himself from any obligation of the contract. In example, he may choose to make the contract voidable. Where the contract states the time of performance, party must perform the contract within the stipulated time. Section 56(1). When a party to a contract to do a certain thing at all becomes a specific times, and fails to do any such thing at all becomes voidable at the opinion of the premise, if the intention of the parties was that time should be of the essence of the contract. Place of performance. If there is a place being specific for the performance of the contract, the parties must perform the contract at the place specific. If there is no place specific, the promisor is under a duty to ask the promise to specify the place of the performance of the contract. Section 50 mentions when a promise is to be performed without application by the promisor and no place is fit for the performance of it, it is the duty of the offerer to apply to the offeree to appoint a reasonable place for the performance of the promise and to perform it at that place. Performance to whom? If it is the intention of the parties that the contract should be performed by the promisor by him personally, particularly when the contract involves skill or expertise, the promisor cannot simply delegate it to someone else. According to section 41, if it appears from the nature of the case that it was the intention of the parties to any contract that any promise contained in it should be performed by the promisor himself, then it must be performed by him personally. Performance by third party. If the offeree accepts the performance from a third party, he cannot enforce it anymore against the offerer. According to section 42, when a offeree accepts performance from third party, he cannot enforce it anymore against the promisor. When the offeree has agreed that a third party will perform the contract on behalf of the offerer, the offeree cannot sue the offerer if the third party fails to perform the contract. This action must be taken against the third party. Discharge by agreement. Section 63 said if the parties to a contract agree to substitute a new contract for it or to rescind or alter it, the original contract need to be performed. Section 64 said every promise may disperse or remain wholly or in a part the performance of the promisee made to him, or may extend the time for such performance, or may accept instance of it any certification when he thinks fit. Based on two sections, the agreement can be discharged in four, which is novation, alteration, rescission, and remission. If contract to be discharged by agreement, all parties must be concerned about it.
Assalamualaikum. I will continue with discharge by agreement. There are four forms discharge by agreement. First one is novation. It is where a new contract is made to substitute the original one. Second, alteration, when all the parties agreed to alter one or more conditions of the contract. Hence, the obligation to perform the original contract is dismissed. Third one is rescission. It is when both parties to a contract agree to terminate the contract they made. Last one is remission. This can be seen in illustration to section 64 below. Illustration B. A owes B RM 5,000. A pays to B and B accepts. In satisfaction of the whole debts, Rm 2000 paid at the time and place at which the Rm 5000 were payable. Discharge by impossibility of frustration. Discharge if there is impossibility of performance of the contract. The contract is in itself impossible to be performed. According to Section 57, an agreement to do an act impossible in itself is void. Illustration A to Section 57, A agrees to B to discover treasure by magic. The agreement is void, so here both parties are under no obligation to perform such a contract. Discharge if either one or both parties aware with the impossibility. If only one party know the impossibility, he must make compensation to the other party. Section 57, subsection 3, when one person has promised to do something which he knew or with reasonable diligence might have known and which the offeree did not know to be impossible or unlawful, the offerer must make compensation to the offeree for any loss which the offeree sustains through the non-performance of the promise. The contract becomes impossible to be performed after it has been made. Section 57, subsection 2, a contract to do an act which after the contract is made become impossible or by reason of some event which the promisor could not prevent unlawful becomes void when the act become impossible or unlawful. Sometimes a contract may be performed at the time it was made, but subsequently something happens which causes the contract to be impossible to be performed. The contracts become impossible to be performed without the fault of the contracting parties. This is also known as the doctrine of frustration under common law. Frustration may occur in several situations. First one is destruction of the subject matter of the contract. Would frustrate the contract as the contract becomes impossible to be performed as contracted. The subjected matter of the contract was destroyed without the fault of the contracting parties, but it could be due to an act of God which was not caused by the contracting parties. There is supervening activities which defeats the whole purpose or object of the contract. If the contract is entered into a specific purpose known to the other party and something happens beyond the control of either party which result in the purpose of the contract to be defeated, the contract is frustrated. Death or personal incapacity. A person who dies or is incapacitated cannot perform the contract. This is so if it is involved personal obligations such as contract of service. The contract is frustrated due to death or personal incapacity. There is change in the law which made the contract becomes unlawful if it is performed. Change of the law is beyond the control of the contracting parties. When the law is amended and the amendments affect the liabilities if the contracting parties, causing it to be impossible to be performed, the contract is frustrated. In applying Section 57, subsection 2, the court will examine the nature and terms of the contract, the circumstances under which it was made, and the event frustrating the contract, including whether it has been self-induced. It must be something which is not at the fault of either parties. Consequence of frustration terminates the contract automatically. The contract is void as it is impossible to be performed. Under Section 66, any person who receives advantage under the contract is bound to restore it or make compensation for it to the person from whom he received it. Discharge by breach of contract. Promisor fails to perform his obligation, there is a breach of contract. Other party that is not breach of contract can take appropriate action which include repudiation or rescission of contract. Section 40, when a party to a contract has refused to perform or disable himself from performing his promise in its entirety, the offeree may put an end to the contract unless he has signified by words or conduct his acquiescence in its continuance. The party not in breach has the option either continue with the contract or to repudiate it. Should he choose to repudiate the contract, he is no longer under the duty to perform the contract. Contract is discharged.
My name is Nazirul Mubin and I will present about the remedies for breach of contract. So what are the remedies for breach of contract? There are several remedies for breach of contract such as rescission of contract, damages, specific performance, injunction, and quantum merit. So for first of all, rescission of contract. If a party breaches his promise under a contract, the party not in breach has the right to terminate the contract. Section 40 of the Contract Act provides, when a party to a contract has refused to perform or disabled himself from performing his promise in its entirety, the promise may put an end to the contract unless he has signified by word or conduct his acquiescence in its continuance. Section 65 of Contract Act stated, if the party not in default chooses to resign the contract, any benefit which he has received from the defaulted party must be restored or returned. Then we take a look at the example of the case. In the case of Muralidhar Chatterjee v. International Film Co. Ltd., it was held that if a party had wrongfully refused to perform his part of the contract, and the party not in default had rightly resigned the contract under Section 40, the party not in default is bound under Section 65 to restore to the party in default any benefit received from him under the contract. Second, damages. Damage means losses or costs incurred due to another's wrongful act. Damages are granted to a party as compensation for the damage, loss or injury he or she has suffered through the breach of contract. The rules relating to damages are provided in sections 74 to 76 of the Contract Act. There are three types of damages. First is ordinary damages, second is special damages, third is liquidated damages. And there are categorized also in three categories. First is substantial damages, second is nominal damages, and third is exemplary damages. For ordinary damages or damages arising naturally, these are damages for any loss or damage caused thereby which naturally arose according to the usual course of things resulting from the breach. For special damages, for any special loss sustained, it is compensation for any loss or damage caused by the breach of contract which is known to the person in breach. And lastly is liquidated damages. Sometimes the parties have stated in the contract the amount of damages to be paid in the event of a breach. Thus, the stated amount is the maximum limit of compensation that can be claimed if there is a breach. For category of damages, substantial damages. It is pecuniary or monetary compensation intended to put the plaintiff in the position he would have enjoyed had the contract been performed. And second, nominal damages consists of a small token award where the plaintiff has proven the breach of a contractual right but suffered no actual loss. And lastly is exemplary damages consists of a sum awarded which is far greater than the actual pecuniary or monetary loss suffered by the plaintiff. They are awarded only in exceptional circumstances. Let me take a look at the specific performance. Specific performance is an order of the court to the party at fault forcing him to carry out the contract according to its terms. Situations where specific performance may be granted. Normally, this remedy would be granted if damages is not an adequate remedy for breach. Section 11 of Specific Relief Act 1950 provide the following circumstance. Section 11 1A stated that when the act agreed to be done is in the performance wholly or partly of a trust. Section 11 1B there exists no standard for ascertaining the actual damage caused by the non-performance of the act agreed to be done. Section 11 subsection 1C when the act to be performed is such that pecuniary compensation for its non-performance would not afford adequate relief. Section 11, subsection 1D stated that when it is probable that pecuniary compensation cannot be got for the non-performance of the act agreed to be done. Section 11, subsection 2 stated, unless and until the contrary is proved, the court shall presume that the breach of a contract to transfer immovable property cannot be adequate relief by compensation in money. The situations where the specific performance cannot be granted. Section 20 of Specific Relief Act lays down the following circumstance where a specific performance cannot be granted. First, a contract for the non-performance of which money compensation is an adequate relief. Second, a contract which runs into such minute or numerous details. Third, a contract which is so dependent on the personal qualification or volition of the parties, such as a contract of employment. Fourth, a contract requiring supervision by the court, such as in building contracts. Fifth, a contract, the terms of which the court cannot find with reasonable certainty. Sixth, a contract which is in its nature revocable, such as a contract of partnership of no fixed duration. This contract can be revoked at any time by a party. 7. A contract made by trustee either in excess of their powers or in breach of their trust. 8. The contract made by or on behalf of a corporation or public company created for special purpose or by the promoters of a company which is in excess of its powers. Means a contract, the performance of which involve the performance of a continuance duty extending over a period longer than 3 years from its date. And lastly is a contract of which the material part of the subject matter supposed by both parties to exist has before the contract is made ceased to exist. Section 21, subsection 2 of Specific Relief Act gives the courts the discretion not to enforce specifically a contract in the following situations: where the circumstances under which the contract is made are such as to give the plaintiff an unfair advantage over defendant, though there may be no foul misrepresentation on the plaintiff's part; where the performance of a contract would involve some hardship on the defendant which he did not foresee, as its non-performance would involve no such hardship on the plaintiff. Section 18, subsection 3 of Specific Relief Act give power to the court to award compensation in addition to specific performance if specific performance is not sufficient to satisfy the justice of the case.
Assalamualaikum, my name is Mohd Shahril and I'm going to present about remedies for breach of contract, which is injunction and quantum meruit. Injunction is a court's order to restrain the doing, continuance or repetition of some wrongful conduct which is against the contract. It is granted at the discretion of the court. Section 50 of the Specific Relief Act 1950 classified that injunction as preventive relief and provides preventive relief is granted at the discretion of the court by injunction. When the contract contains a negative agreement, breach of that agreement can be prevented by injunction. There are 3 illustrations. Illustration A lets certain land to B and B contracts not to dig sand or gravel thereout. A may sue for an injunction to restrain B from digging in violation of his contract. Illustration B. A trustee threatens a breach of trust. His co-trustee, if any, should and be beneficial owner may sue for an injunction to prevent the breach. And lastly, illustration C. The directors of a public company are about to pay dividend out of capital or borrowed money. Any of the shareholder may sue for an injunction to restrain them. Next is types of injunction. Injunction can be divided into 2 types. It can either be temporary or perpetual. The first one is temporary injunction. Section 51 bracket 1. Temporary injunctions are to continue until a specified time or until the further order of the court. They may be granted at any period of a suit and are regulated by the law relating to civil procedure. The purpose of temporary injunction is to preserve the status quo pending the resolution of a legal action. Next is perpetual injunction or permanent injunction. Section 51 bracket 2. A perpetual injunction can only be granted by the decree made at the hearing and upon the merits of the suit. The defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act which would be contrary to the rights of the plaintiff. Perpetual injunction is to prohibit the defendant permanently from doing an act or asserting a right which is against the plaintiff's right. It is only granted after a full trial before the court and upon the merits of a case. Next is situation where injunction cannot be granted. A contract that cannot be enforced by specific performance could not also be subjected to an injunction. Section 54 bracket F states that an injunction cannot be granted to prevent the breach of a contract, the performance of which could not be specifically enforced. For instance, Section 20 bracket 1 bracket B of the Specific Relief Act (SRA) provides that a contract of employment which is so dependent on personal service of a person cannot be specifically enforced. Since specific performance cannot be enforced, injunction will not be granted either. However, this is a general rule. The exception is contained in Section 55 of the SRA 1950, which provides an exception to the above rule. And lastly is quantum merit. Quantum merit, as much as he has deserved, is a claim for reasonable remuneration for work done or service supplied under the contract. In the event of a breach of contract, the claim arises in two kinds of cases. The first one is where one party abandons or refuses to perform the contract. And second one is where work has been performed and accepted under a void contract. If there is an existing contract which does not have the details such as the price is not fixed, the seller is entitled to a reasonable price as a quantum merit. That's all from me. Thank you.